Alrighty, everybody, welcome back to another episode of Subscribing to My Podcast. Because I have a new guest on the show every week, it's very difficult to get consistent viewership. So if there's one thing that you can do to support me and the guest featured on my show is by interacting with the video. You can always unsubscribe later if you hate me or the content. Without further ado, here's your episode with Dr. Miko Wilford is a professor and researcher here at Iowa State. Fresh blood came in a year ago with a specialized interest in psychology and law here, and I'm actually a part of her lab researching psych and law among some other things, but she's also one of the people involved in one of the advisors for PsyChi, and so I actually spent a lot of time with Dr. Wilford and her cohort of researchers and people, but Dr. Wilford, it's awesome having you on today, and I want to give you an opportunity to introduce yourself and tell the viewers some of the important things that they might need to know about you, but go ahead and introduce yourself.
Sure. Thank you for having me on. So yes, my name is Miko Wilford. I just joined the Iowa State faculty, as Elijah said, just this year. However, I actually am a native to Iowa State. About 10 years ago, I earned my PhD in psychology from Iowa State University. On the way to that PhD, I also earned a master's in psychology at Iowa State. And then before that, I actually did my undergraduate at Iowa State as well. I got dual degrees in psychology and political science as an undergraduate. So although I'm new to the Iowa State faculty, I'm not new to this campus. And it's been such a blessing to be able to make it back here. I've always loved this campus and this university. And it was such a great opportunity to be part of this show that's obviously focused on the university. So yeah, since moving to Iowa State, I have reestablished my research lab, which is called the PLEA lab, which is an acronym for Psycho-Legal Experiments and Applications, and for which Elijah was actually our first Iowa State member after moving it here from the University of Massachusetts Lowell, which is where I got my first faculty position and where I was for 9 years from 2014 to 2023. In addition to being a faculty member in the Department of Psychology, affiliated with the cognitive area, but also the psychology and law concentration, I also do consulting on a few criminal cases, usually pertaining to potential eyewitness memory issues, but also I'm trying to grow interest in consulting on cases that might have involved potentially false guilty pleas. Those cases are harder to come by because, of course, they have to be post-conviction cases, which are just going to be more rare in general. But it seems like there's a growing recognition that there are factors that lead innocent people to take these plea offers, and I'm trying to increase the spotlight on those issues, both via consulting as well as the research I conduct in the plea lab.
That's really cool. What do you think, if you can kind of walk me through the journey of how you discovered that you were interested in psychology and then legal psychology, and then how that kind of shaped your career path and then how it led you to where you are now?
Yeah, so I actually knew from an early age that I was interested in psychology. I think I initially became interested in psychology back in middle school or something ridiculous like that. Basically, I think as soon as I realized it wasn't realistic to become an actor or actress of some kind, I pivoted to psychology as a more realistic but just as interesting career option. And I think it wasn't until high school where I really started narrowing my interest in psychology. So I knew I was interested in psychology, but I didn't know exactly what I wanted to study or what I wanted to do with it. And then in high school, I was given an assignment to write very broadly about any woman who had had a significant impact in the 20th century. So I just Googled influential female psychologists, and Dr. Elizabeth Loftus was one of the first people to come up, and I read about her research, and she had a number of popular press books. One of them was called The Myth of Repressed Memory, and it was about this sort of series of child sex abuse cases that were prompted by individuals who, during therapy, had allegedly recovered these repressed memories of being abused as children. When she heard about these cases, she was very skeptical of them, so she started doing research on repressed memories and false memories. And I thought her book was fascinating, and I thought her research on that, as well as the misinformation effect, was really fascinating. And this intersection and application of psychology to the legal system was really compelling and interesting to me. So I started learning more about that area. And then actually, I applied for a number of programs in undergraduate, University of California, Irvine being one of them, because Dr. Elizabeth Loftus is there. And economically, it just made the most sense to come to Iowa State because I'm an Iowa native. I grew up in Cedar Rapids. So I ended up coming to Iowa State, not knowing at the time, though probably should have, that the other huge name in eyewitness research, Dr. Gary Wells, was a professor here. When I finally figured out that he was a faculty member here, I actually couldn't get in his research lab because it was very high demand. It was very popular. So I think I did not break in to his lab until my junior year of undergraduate. And at that time, we had a very limited amount of time, of course, to get to work together. So although it's typically not advised that you go to the same graduate institution where you got your undergraduate degrees, because he and I had just had the opportunity to work together and we did work really well together, even starting as a junior in his lab, we thought of a cool study idea my senior year, and he decided to give me an offer to stay here for my PhD, which I, of course, did eventually. And then I worked with him for my graduate career, but around the time I was doing my master's thesis, I was still very much interested in eyewitness research. I still do eyewitness research to this day. But I started becoming interested in other areas of psychology and law research that were perhaps less developed than the eyewitness area. And of course, I think I felt this need to do something a little bit different than Dr. Wells, because I was never going to be as successful as he's been in conducting eyewitness research. So I was really open to doing some different type of research, still in the area of psychology and law. And around that time, I just happened to come upon a New York Times article talking about the disappearing trial and this trend toward guilty pleas in the legal system. And I did not realize before reading this article that guilty pleas determine such a substantial proportion of criminal convictions in the country. And I thought it was fascinating. And then when I tried to look up research on the area, I was shocked to find very little out there, especially conducted by psychologists. So I decided to do my first study on plea decision-making for my master's thesis. Then I also did my dissertation on plea decision-making and have sort of stuck to that area of inquiry. I still, like I said, do research on eyewitness memory, but the majority of my research now is looking at what drives people to accept guilty pleas, particularly when they're actually innocent of the crime for which they're being accused.
Yeah, and the plea bargain research is interesting because that's relatively new just in the scope of all research as well, isn't it?
It is a relatively young area. So when I started it, so like I said, the first plea study I did was for my master's thesis, which would have been back in 2012 is when I finished my thesis. So I probably started it in 2011. And at that time, there were maybe 3 to 4 other people in psychology who were doing this work. The field has grown significantly since then, but there's definitely still a lot of catching up to do with regard to the research literature being as substantive and complex as eyewitness research or juror decision-making research or research on interrogations and confessions. All of those areas I would consider older and more developed literatures than the research on guilty pleas and plea decision-making.
Well, I thought the plea decision-making thing was super interesting, especially when you had introduced it to me when we had met for the first time in that lab. Could you kind of explain how that works and what you're exactly talking about when you're talking about like plea decision-making and what that looks like?
Yeah, so I think the first thing to note about guilty pleas and plea decision-making, and probably why it's such an under-researched area, is there's really no one way with regard to what it looks like or what it involves. There are numerous variations. They can take minutes, they can take days, they can take weeks, they can take years. They sometimes, most typically, involve the defendant verbally admitting guilt or accepting responsibility for the crime to which they're accused. But even that is not a consistent requirement. People can accept a guilty plea without ever actually pleading guilty or admitting guilt. There are types of pleas that exists specifically for that. So there's a plea called, I'm going to butcher the Latin. I did not take Latin, but it's a nolo contendere plea, which is Latin for I do not contest. Essentially, when people accept those types of plea offers, they don't make any public statements regarding whether they're actually guilty or innocent of the crime to which they're being accused, but they still accept a conviction, and it's still considered a guilty plea. There's another one called an Alford plea, for which the defendant can actually actively maintain on public record that they're innocent, so they can proclaim their innocence while essentially acknowledging that there's a possibility that the state could still prove them guilty at trial, and therefore they're pleading guilty despite being innocent. So I think those two types of pleas really demonstrate how little standardization there is in the plea process. But ultimately, what typically happens is someone's accused of a crime, and often they have the option, instead of taking their case to trial, which can be extremely resource intensive, can take a lot of time, obviously involves consultations with an attorney's time, strategy, all of these different components for trial preparation. At some point, they're usually approached by a prosecutor, or the prosecutor might approach their attorney if they've already secured a defense attorney with some sort of discounted offer. So usually reduced charges or reduced sentence recommendation. And essentially, the offer is usually if you agree to waive your constitutional right to a trial and accept conviction for these reduced charges, or the same charge but with a recommended reduced sentence, then we'll proceed to what's called a plea colloquy. At this juncture, the defendant does go before a judge for an extremely abbreviated hearing. And I want to emphasize, this is not an abbreviated trial. This doesn't resemble a trial in any way, shape, or form. The only purpose of that hearing is for the judge to determine whether the defendant is accepting the plea knowingly, intelligently, and voluntarily. So the judge will typically ask the defendant some preset number of questions, determining whether they believe that the defendant is entering that plea knowingly, intelligently, and voluntarily. Things like, do you understand what you're pleading guilty to? Were you offered anything in exchange for pleading guilty aside from whatever the actual agreement might be? Those hearings, we found, last on average, for misdemeanors, they can be as short as 3 minutes. For felonies, they tend to be a little bit longer, but can also average about 7 minutes. And after that hearing, the defendant's convicted via a guilty plea.
Okay, and so some of the contentions with this are that you might be, as a lawyer or as prosecution, you might be tempted to push for this option instead of a trial because it saves you money and time and resources, even though it might not be ethical to make this decision. Is that kind of some of the accusations or some of the research areas that we're looking into?
So to be clear, I don't make any judgments regarding the ethicality of the practice for respective attorneys. I will say, though, that the value of the system absolutely is its efficiency. So exactly what you said. It takes far fewer resources from everyone involved to have a case end with a guilty plea than a trial.
Right.
So that said, there can be arguably competing motivations with regard to whether saving those resources is worth a defendant being convicted via such an abbreviated process.
Right. So then, like, the worry is that some people might plead guilty even though they are innocent in avoidance of a trial, or to use these resources, or to maybe a worse trial if they were found guilty even though they were innocent. Is that kind of some of these worries? Or I'm trying to hedge out like the purpose of the research so that people can kind of understand how important this is.
Sure. So yes, my research in particular has been focused on false guilty pleas. So those are guilty pleas that were submitted by people who are in fact innocent. So we actually already know that this occurs in the real world. There's this great database called the National Registry of Exonerations, which is led by, I believe it's the University of Michigan Law School in collaboration with University of California, Irvine, as well as a few other academic institutions. And essentially their objective is to document every known exoneration, so every overturned conviction essentially in the US, and include it in this database. And the last I think I checked, the database includes just under 4,000 cases, and just under a quarter of those involve the defendant pleading guilty. So we have around, I think it's about over 800 cases of known false guilty pleas where innocent defendants, due to the circumstances surrounding the plea offer, chose to plead guilty despite the fact that they were innocent. So, and it's worth noting that that is likely an underestimation of how frequently this is actually occurring in the real world, because it's extremely difficult to overturn wrongful convictions. Once you're convicted, the post-conviction process becomes much more difficult, because before you're convicted, right, the presumption is that you're innocent. It's the prosecution's burden to prove that you're guilty. Once you're convicted, that burden flips. So now you actually have to prove that you're innocent, that there was something constitutionally wrong about the process that led to your conviction, right? There's a number of different ways you could try to go about overturning a conviction, but all of them put a heavy burden on you to prove that you're innocent or that your conviction was erroneous in some way. So it's very difficult to overturn convictions. So when I say we have 800 known cases of false guilty pleas, the actual number is likely magnitudes greater than that because of the difficulty associated with overturning any conviction. And plea convictions are actually even harder to overturn, because when you agree to plead guilty to a crime, you're often agreeing to waive a number of avenues you would have for appeal if you were convicted after a trial. So you have a reduced number of ways that you can try to overturn that conviction when you accept a guilty plea.
That's super interesting. So I read there was some sort of document that had a lot of the tenets of plea research that I was looking through, and kind of what the ideas and what the purposes of that was. And I saw that one of them is kind of standardizing this process so that people know exactly what they're getting into when they're doing the plea process. And other things is, what are some of the prescriptions that we're kind of looking for in standardizing this plea process or looking at plea bargaining?
Yeah, so a lot of what's driven my research is the idea that, thankfully, we do find in the research intuitively that innocent people are less willing to take guilty pleas than guilty people, which is a good thing. So our goal should be to preserve that natural tendency that innocent people have to not accept pleas. And the issue, though, that we have in our current system is that there are a lot of pressures that can push innocent people to accept a plea despite their initial reticence to want to plead guilty. So the goal of my research broadly is to really investigate what these pressures are and ways that we can mitigate those so that we can preserve, again, that hesitancy that innocent people have to not want to plead guilty for something they're not actually guilty of. So one of the things that I definitely think is problematic with regard to current plea practices is the ability to detain someone pre-trial and then offer them a plea for what's called time served. So essentially what can happen is, after someone's charged with a crime, for various reasons, often surrounding the fact that they are economically disadvantaged and can't afford cash bail, they're incarcerated prior to their trial. During that incarceration period, a prosecutor is allowed to offer them a plea for time served, which essentially means you can leave jail today if you agree to accept conviction for typically a misdemeanor. So they're going to have that criminal conviction. They're going to have all the collateral and direct consequences that come with that criminal conviction. But arguably, they don't care about that because it means they get to leave jail that day. I think from a psychological perspective, and I have some research to back this hypothesis, that of course is going to be an extremely tempting offer for anyone, regardless of whether you're innocent or guilty. If you're in an environment like jail that no one is going to find to be a pleasant environment, right? It's keeping you away from people you love, work you need to do, etc. It's going to be extremely tempting to get an offer for time served, regardless of your actual guilt status. So those are the types of variables that I'm interested in. The types of variables that are going to tempt anyone, regardless of whether they're innocent or guilty, to plead guilty. I think pretrial detention is probably one of the easiest for people to understand how that could lead even an innocent person to plead guilty. That said, I think people don't understand the scope of this problem. So most people aren't aware that the majority of people in jails in the US today are people being held in pretrial detention. They are people who have not been convicted for the crimes for which they're accused. So I think overall, it's a little over 50% of people currently in jails are being held pretrial. So the scope of the problem is, I think, much bigger than most people would imagine.
Dang, I never thought about it in the kind of context of using this. Do you think that's kind of like an intentional choice that they're choosing to come and talk to them, or they're choosing to come and offer these plea deals when they're incarcerated, or is that just kind of like that's how the cards were dealt? They are going in there and they just have to talk to them at that time.
I do not believe that the vast majority of prosecutors are intending to get innocent people to plead guilty. I want to be very clear about that.
Right.
I do not think that's the intention at all. I think we've created a system that introduces pressure on defendants that it's very hard to be empathetic to when your job is to clear your docket, right? So I think from the perspective of prosecutors, they're doing their job. And the problem is we've created a system that values efficiency so much that their job often does involve working within a system that introduces a lot of pressure for defendants who might be innocent still to plead guilty.
This is really interesting. So the people who disagree with this sentiment, what are they normally saying? Like, is there a body of research that kind of doesn't think that this process needs to be changed or altered in any way? And then what are they kind of saying?
So I think there's still a broad contingent of people, particularly legal practitioners, who don't believe that innocent people plead guilty. They just really don't believe that that happens. They don't feel like there's a lot of evidence that that happens. So I've read some pieces by a former judge named Paul Castle, who's written a lot about his calculations regarding the wrongful conviction rate and how he believes it to be extremely low. I think his estimates put it around like 1/4%, something like that. Most wrongful conviction scholars believe it's probably closer to 5%. That's obviously a huge difference. That's a huge gulf to try and bridge. So I think for a lot of individuals, that's some of the motivation is they really just don't believe that innocent people are pleading guilty. So they really defend this process by saying that it's actually providing really useful concessions to defendants who would otherwise get far more punitive sentences. So, I mean, if you remove the possibility of false guilty pleas, then
there's not really a huge issue.
Yeah, there's not really a problem with the current system. I mean, you might have some issue with the discrepancies that emerge for people who are pleading guilty versus people who are going to trial. But if they're all guilty to begin with, then I guess, it's not going to elicit probably much sympathy from the vast majority of people. I would still argue the system is problematic even if you're not focused on false guilty pleas, because I think then it's still a system that rewards people who have more resources than other people because it's a negotiation-based system. So for people who say, I don't really believe that innocent people would plead guilty, right? This same resistance was faced by people who do research on false confessions, and there continues to be people who don't really believe that people would falsely confess to crimes that they didn't actually commit, yet we now have decades of research demonstrating that that does happen, that people will falsely confess. So we're kind of dealing, again, it's younger literature, so we're dealing with that sort of same first obstacle of people just being initially skeptical that this happens, that an innocent person would plead guilty to a crime that they didn't commit. What's interesting is, in the plea realm, I feel like it's easier to imagine a scenario in which an innocent person would falsely plead guilty than arguably it is to imagine a scenario in which an innocent person would falsely confess. Because unlike an interrogation where law enforcement are explicitly told that you can't offer someone something explicit in order to get them to confess, right? You can't say, I'm going to tell the DA to only sentence you to X if you confess right now, right? That's illegal. It's an illegal way to elicit a confession. That's perfectly legal in the plea context. That's what plea negotiations are, right? Is to offer someone explicit benefits in exchange for pleading guilty. So I think it's interesting that we're still facing that same objection, even though I can think of numerous contexts where a perfectly rational person would still plead guilty falsely under the current system that allows so many different pressure points on defendants to push them into pleading guilty.
Yeah, this is interesting, and it seems like you are kind of battling certain incentives. You are kind of battling anytime there's a reform that's happening. It takes a lot, I feel like, to change the current system, no matter what it is, just because you have a lot of people who have built their careers doing it a certain way, doing it however, and now you're coming in to change it, so you're going to probably receive some backlash in that way too. But that seems really frustrating. When you're thinking about your perfect legal system, you're going to build it from the ground up, you're going to change certain things. What are some of the implementations that you would do right now, if you could, to change the legal system or to change some of these aspects?
Yeah, so it's worth noting that although there are people who are skeptical of the current system having issues, I would argue that they're a relative minority, to the extent that I think the vast majority of people are willing to acknowledge that there are issues with the system. They might disagree regarding what those exact issues are, but I think the vast majority of people, practitioners, that includes prosecutors, defense attorneys, judges, are willing to acknowledge that the system is not perfect. That said, there have been a number of efforts to try to bring people together from across both aisles, across both sides of the adversarial legal system, to come to some agreement regarding what reforming this process might look like. So the American Bar Association's criminal justice section actually created a plea bargaining task force that was led by Lucian Durbin, who's a law professor at Belmont. And as part of that task force, he assembled people, again, from both sides of the adversarial aisles, so prosecutors, defense attorneys, judges, to come to an agreement regarding what the issues with the system are and what potential reforms might be. So that task force published its report, I think, just last year, and it included a number of recommendations as well as just acknowledgments. So one of the things they did explicitly acknowledge in that report is that innocent people do plead guilty falsely, that does happen. And they were able to get agreement within the task force that that is an issue, and it's one that people should be aware of, so that, you know, that has to be the starting point, is that you acknowledge that that can happen, so that you then become more sensitive and conscientious of the factors that could contribute to that happening. So in addition to acknowledging that innocent people plead guilty falsely sometimes, they also had 13 other principles. So they did call them principles and not recommendations for reform. They were kind of sort of sensitive to this idea that we're just trying to provide guidelines. So they had 14 principles. One was that innocent people do plead guilty falsely. And then they had other principles concerning some of the issues we've already talked about. So things concerning pretrial detention as a potential risk factor for increasing pleas across the board, but also from innocent individuals. They also talked about trying to reduce the sentencing discrepancies between what's offered at the plea phase versus what is then faced if they're convicted at trial. They talked about providing discovery to defendants during the plea process. So another issue that people might not be aware of is prior to trial, we all have this constitutional right to evidentiary discovery, right? So that was established in Brady v. United States. This idea that if the prosecution has potentially exculpatory evidence, that's something they're obligated to share with the defendant and their team, so that they're aware of that evidence going into trial. That right has not been extended to plea negotiations. So it is possible a prosecutor could have information about your case and not share it with you prior to offering you a guilty plea. And there is nothing on the book saying that there's any legal issue with them doing that. So one of the principles explicitly said that defendants should have a right to any evidentiary discovery during the plea phase. And then, of course, they had a number of other principles as well. In addition, there's also a coalition of people, again, across the political spectrum. Some of the members are individuals, but they're also entire organizations. So I believe the Cato Institute is one. I think the ACLU might be another, but it's this coalition called the End the Trial Penalty Coalition. And it's similarly motivated to try to reduce the pressure on criminal defendants faced with these plea offers, for which, again, the penalty discrepancy between what they're offered in exchange for pleading guilty versus what they could face if they're convicted at trial can sometimes be extremely large. So that coalition, of course, is motivated to try to, I don't think they want to eliminate the sentence discrepancies, but they want to bring them within what they believe is a reasonable magnitude. And then again, there have been organizations, so the National Association of Criminal Defense Lawyers on the defense side has been very outspoken about issues concerning the plea process. But then on the other side, you have an organization called Fair and Just Prosecution, which has also been very concerned with ensuring that prosecutors use their immense amount of discretion in a way to try to better guarantee fair outcomes and to inform prosecutors of the risk of false guilty pleas for which they might understandably be unaware, and discuss issues that could help them to exercise their discretion in a more consistent and fair way to try and reduce the risk of wrongful convictions.
So just real quick, you said 4:45 or 4:15 is when you have to go?
4:50.
4:50, cool.
Yes.
But there was a point that you mentioned there that I found kind of interesting, and I'm not super up to date with how the legal system works, but when you say decreasing like the margin of punishment that you're going to get if you from the what is it the trial punishment, basically like if you go to trial, like decreasing the amount of difference you get punished for going to trial versus accepting the plea bargain. Is there already a punishment for like a guilty person goes to trial to try to claim innocence, gets found guilty? Is there an increased sentence there? And then if you decrease that sentence, do you run the risk of letting guilty people, like, do you kind of get what I'm asking here? Like, if somebody's guilty and they try to go to trial to prove innocence, and then they're proven guilty, they probably should receive like a slightly worse sentence because they tried to get out of it.
Right.
Or like, is this how it works? Is it not? Like, kind of.
Right. So, so there's obvious need, and I want to be very clear that I recognize the obvious need that you're going to have to offer some sort of concessions to defendants when you're offering them guilty pleas, or why would they take them, right? Why would somebody agree to plead guilty to a crime if they could potentially go to trial and be acquitted, right? Whether they're guilty or not, that possibility exists that they could be acquitted at trial. So in order to negotiate with the defendant, that's why these are allegedly called plea bargains, plea negotiations, right? You have to offer some sort of concessions on the sentence they would receive at trial in exchange for pleading guilty, because when they plead guilty, they're accepting conviction, right? They're eliminating any possibility that they'll be acquitted, which is a possibility at trial. So I readily acknowledge, as do the vast majority of people who are even calling for reform in this area, that there need to be sentencing concessions in exchange for a guilty plea. You can't eliminate that from this process, or defendants won't plead guilty, right? Why would you plead guilty if there's nothing in it for you? That would be completely irrational. So the issue is not that there's a reduced sentence in exchange for pleading guilty. The issue is, what should the magnitude of that difference be? So the case that I would present to you for you to sort of judge, because essentially the issue here alleges there is no problem with offering people a sentence discount in exchange for pleading guilty. There's no issue with that, right? Because again, the idea is if you don't offer them some sort of discount, they're not going to plead guilty. They're going to take their chances at trial because they could be acquitted at trial. The issue, however, is if you're not giving sentence discounts for guilty pleas, but rather you are penalizing people who take their cases to trial. Because the right to take a case to trial is a constitutional right for which you cannot be penalized, right? So I'm speaking from a legal standpoint, not a judgment standpoint, and saying that the question then is whether in these cases, defendants are being offered discounts in exchange for a guilty plea, which is constitutionally fine, or whether they're being penalized for refusing to plead guilty and taking their cases to trial, which would not be constitutional. That would be problematic. And I think that judgment is a hard one to make, right? At what point does the discount become so excessive that it's a penalty? That's a really hard question to answer. And there are some groups that have recommended discounts of certain magnitudes and said that the discount shouldn't exceed 15%, 20%, 25%, 30%. I've seen recommendations in those ranges. I'm not going to make a strong statement regarding what that percentage should be. However, I do think there are cases where it's difficult to argue that the sentence differential was just a discount in exchange for pleading guilty. And the case I would bring to your attention is there was a case of a defendant named Weldon Angelos. So Weldon Angelos was accused of trafficking marijuana on 3 different occasions. And according to the police informant that he allegedly sold this marijuana to, he was in possession of a gun in all 3 instances. Now, I want to be very clear that the informant did not claim he shot the gun, brandished the gun, or even took it out. So the informant claimed that during the first instance of drug trafficking, the gun was, I think, in an ankle holster. And then for the 2 subsequent instances, it was in his car, which is still considered possession, apparently. So gun possession during a drug trafficking crime is a mandatory minimum crime. For the first offense, it carries a mandatory minimum of 5 years. For each subsequent offense, it's a mandatory minimum of 25 years. So the prosecutor in Angelos's case offered him a guilty plea for 15 years, said if you plead guilty to gun possession during a drug trafficking crime, and of course the drug trafficking itself, then I'll recommend a sentence of 10 years for the drug trafficking, and I will only charge you with 1 instance of gun possession during a drug trafficking crime, which would carry the 5-year mandatory minimum. And this is a clear case which underscores the importance of charging decisions, which are entirely under the discretion of prosecutors. Because in cases involving mandatory minimums, prosecutors have an enormous amount of sentencing discretion because the charges determine the sentences. So in this case, the prosecutor was able to unquestionably offer a discount of 40 years by simply saying, I will not pursue the other 2 charges of gun possession during a drug trafficking crime. I'll only pursue 1 charge of gun possession during a drug trafficking crime. So he was able to offer Weldon Angelos a sentence of 15 years if he agreed to plead guilty, then said, if you don't take that plea, I'm going to charge you with all 3 counts of gun possession during a drug trafficking crime, which will carry a minimum of 55 years. So that's a 40-year sentence differential. No change in evidence, no change in the severity of the underlying crimes. The simple difference is, if you make me take this case to trial, you will do 40 years longer in prison.
I see. So if you were to say like so it's kind of a perspective thing. It's like, is this punishment? Is this like a benefit to you?
Right.
What would you suggest for that case specifically then that would be closer to, you don't have to obviously die on a specific hill, but like, what would you say is closer to more of the benefit of the plea as opposed to a punishment?
I mean, this case specifically, my first issue is going to be with the mandatory minimum penalties, period. I have a big problem. Lots of other people have big problems with mandatory minimum sentences because they remove sentencing discretion in cases where there should be some discretion, right? The judge should have been able to exercise some discretion in this case. And interestingly, Paul Castle, who I mentioned earlier, who's very skeptical of wrongful convictions, he was the judge in this case, and he was very outspoken about having to sentence Angelos to 55 years and how upset that made him. So he compared Angelos's 55-year sentence to the sentence of people who had been implicated in, I think there was like a drug ring that resulted in the murder of 3 individuals, the rape of 3 children, so he compared it with a number of other 3-count crimes and sentences for which Angelos's sentence was magnitudes greater. All of the sentences he compared Angelos's sentence to were not victimless crimes. They were not nonviolent crimes. So my starting issue is with mandatory minimum sentences. I think they result in often draconian sentences that I would argue are not reflective of what the vast majority of U.S. citizens would feel someone deserves for being charged with those crimes. So that would be my first issue with Angelos's case, is just that the judges' hands were tied from the get-go in his case to sentence him to 55 years for 3 counts of gun possession while trafficking marijuana. With regard to other issues in the case, I do think that the sentence differential in Angelos's case specifically likely represents a penalty for him rejecting his plea and taking the case to trial. I think a 40-year sentence differential is dramatic.
It's really high.
Yes. I'm not going to say it couldn't be warranted in certain circumstances. So I will note, I have had conversations with some extremely compassionate, conscientious prosecutors who are concerned about having hard and fast rules regarding sentence differentials because they have to prosecute some very difficult cases, right? So they have to prosecute cases where a child was the victim of rape and they don't want to make that child testify at a trial. I will be the first to say that I can't empathize with how difficult it would be to try to tell a child that if you want this person who did this terrible thing to you to go to prison, you have to rehash all the trauma, you have to be cross-examined, you have to face a jury. I can be very empathetic to why in those cases these sentence differentials can be pretty dramatic because of the savings they represent to re-traumatizing victims of particularly violent and terrible crimes, which is why I don't advocate for a specific number. Exactly. I think it's a case-by-case basis. I think prosecutors have that discretion. I don't have a problem with prosecutors having that discretion. That said, I do think we need to be more transparent then about when those differentials occur and what the justification is for them. Because in Angelos' case, you didn't have a victim who was going to be forced to testify at trial. So I would be very interested in why the prosecutor felt a 40-year sentence differential was justified in a case involving nonviolent drug offenses.
Right, and so this kind of goes back to, in the principles, I read that there was a lot of stuff about like writing this stuff down, making it kind of a formal process of doing these things. You'd probably discover a lot of these reasonings in that process, and that might encourage people to lower that differential as often as they can too.
Absolutely, yeah. I think we just need more information about how this process is operating, what it looks like day to day, what the justifications are for seemingly dramatic sentence differentials when they happen, whether they are warranted, whether they're arguably less warranted, right? There are going to be deviations. Everyone's human. People are going to have good days, they're going to have bad days, but all the more reason why we need to document what are these differentials, why are they there, what are your reasonings for it. You know, one of the big issues with plea negotiations as well is we actually don't know. So we refer to this process as a negotiation or bargaining process, but we don't actually know if that's true, right? So we have some evidence from a number of jurisdictions that there's really no bargaining or negotiation. What's happening is a prosecutor is saying, you know, there's sort of a standard or like going rate of this is what you're charged with, so I'm going to take it down to this less severe charge, and that's what I'm offering you. It's not based on the case. It's not based on the evidence in the case, police report. That's just standard practice in that jurisdiction. So there's no negotiation. It's just this is the deal, take it or leave it. So we don't even know how often there is a bargaining process. And then when there is a bargaining process, we don't know, is the prosecution typically initiating it? Is the defense typically initiating it? What's the average number of offers? How much, again, distance is traveled during that bargaining process? Do you see a lot of sentence change? Do you not see a lot of sentence change? Are charges dropped? Are they added? Are they, again, we just don't have enough information about what this process really looks like to be able to have full confidence in the validity of the outcomes that it's producing.
Gosh, this is stressing me out. I wonder if how this kind of operated for so long without any of this information, and then was there something that kind of sparked the interest, like the group interest in researching this plea bargaining stuff, or like when did this kind of start and why did it start? Because it seemed like so long we were operating with this, and then all of a sudden we're like, maybe we should actually think about this because this is kind of going under the rug for so long.
Yeah, that's a great question. So there have been a few, particularly legal scholars, who I think have done a great job writing pieces covering sort of the history of plea bargaining in the United States. And I think one of the biggest takeaways is a lot of people today want to pretend that plea bargaining is just sort of inherent to our process. It's always been part of the criminal legal system in the US, and that's actually not true. Plea bargaining emerged largely in the last 100 years or so, I'd say. There were always cases where people might have spontaneously pleaded guilty in the hopes that the judge would be more lenient or more forgiving in their cases. But as far as this actual negotiation process that we're seeing now, that has not always been endemic to our system. So from my understanding, and I'm not a history scholar, but I've read pieces by Albert, I'm going to apologize for potentially mispronouncing his name, but I think it's Albert Alschuler, and then also who I mentioned earlier, Lucien Durbin, have both written pieces covering the history of plea bargaining in the United States. And from my understanding, it really started emerging, I think, around the post-Civil War. It started increasing in prevalence, but really became a more dominant force in the legal system, I think, around the Prohibition era, where prosecutors were just overwhelmed with the number of cases they were expected to adjudicate. And this is where you really see sort of why it's become endemic to the system today, because our system is now so reliant on prosecutors processing so many cases, right? We criminally convict so many of our citizens. We incarcerate more of our citizens than any developed country, again, by magnitudes more. That kind of system that sort of prioritizes criminalizing so many behaviors that so many people engage in is going to require efficiency. And that's really where you saw plea bargaining emerge, is when the system got overwhelmed and needed more efficiency. That's where you start seeing plea rates increase. And of course, now we have rates of 95 to 97%, which I think underscore the number of people we're convicting of criminal offenses in this country now.
So if you were to look at the legal system as a whole, would you say that this is kind of one of the most prevailing issues, or what would you ascribe as like kind of your most prevailing concern as far as the legal system goes?
I mean, I think everyone's probably biased to think that what they research is the most important thing.
Yeah.
So I will start by sort of checking my own bias and saying, I, of course, do think it's one of the most pressing issues in the legal system. That's why I study it. That's what drives me to study it. The one thing I would say with regard to other areas of psycholegal research, which I do think are important, but unlike those areas, we talk about false confessions, we talk about eyewitness misidentifications. When we talk about false guilty pleas, we're talking about convictions, right? So everything else, we're talking about evidentiary issues that could lead to wrongful convictions. When we talk about false guilty pleas, we're talking about wrongful convictions because that's what they are, right? So although a false confession is extremely incriminating evidence, and it's extremely likely that someone who falsely confesses will eventually be wrongfully convicted, it's not a guarantee in the way that it is if you falsely plead guilty, that is a conviction, right? You're done. So I guess I would lean on that for justifying my bias of saying this is one of the most pressing, if not the most pressing issues for the criminal legal system, because false guilty pleas are representative directly of wrongful convictions. And I think, so I think also issues with the plea system are really linked to issues with the system as a whole, right? So the issue of pretrial detention, you could argue, is relevant to the issue with the plea system and the system as a whole. So I think, when I sort of say, like, what is the most important thing, if I'm referring to issues of the plea process, I'm referring to lots of other issues as well, because so many of these things sort of go together, right? It's a constellation of things that are producing suboptimal outcomes in our legal system. And I think the plea process is part of that, but I think it includes a lot of the other issues that people would highlight as contributing to these unjust outcomes.
Yeah, and that's kind of the answer that I was expecting, but I think it is really cool to kind of like, hedge out why you do this and why you think it's so important. I think another interesting thing that you said earlier as part of your introduction is that you'll do a lot of consulting for cases. And I'm very interested in like what that looks like, and more specifically, what kind of information do you think that you're kind of constantly bringing to the court cases or to the cases that you come to when you're being a consultant? Like, what do you find you're kind of repeating as you're consulting these cases?
So most of the cases that I've consulted on, as I mentioned earlier, they're typically potential wrongful identification cases. So usually these are cases involving what we'd call a stranger identification. So someone witnessed the crime, saw the culprit, but didn't have prior familiarity with the culprit. And then at some point identified a suspect that might or might not actually be the culprit. So usually I'm asked to review all of the evidence in these cases and determine whether there are potential reasons to believe that the identification might not be reliable. So what I do is, I review the evidence, could include things like police reports, whether there's any statements regarding the identification procedure that was administered to the witness, any statements from the witness regarding how good a view they had of the culprit, how long the culprit was in view, all of the evidence pertaining essentially to how the event was witnessed and then how the identification was made. And after reviewing all that evidence, I essentially determine whether research has investigated factors that are relevant to that particular case. So I think an easy example is there's a wealth of research that's demonstrated that people have what's called an own race or cross-race bias, such that we are better at accurately identifying people of our own race than people of other races. So that's one area of research where we've clearly established that crimes involving cross-race identifications are going to produce less reliable identifications. But I think the most important thing is I would never go into one of those cases and say, this witness is incorrect, right? Mm-hmm. My job is to talk about the factors involved in the case and whether those factors, given what we know through research, would sort of undermine or even potentially increase the likelihood of a accurate witness identification. Right, so it could go either direction.
Mm-hmm. Mm-hmm. So are you normally brought in then when there's like skepticism towards an identification already? Or are you kind of, is there always going to be a person involved when there's identification?
Yeah, so typically I'm called usually by defense attorneys when they believe that there are reasons to question the reliability of a witness identification in the case.
That must feel really cool that you're kind of just like the person who knows things about about something. Like they're like, oh, we need to call in our expert here to to come and look at this and tell us the research on how it happens.
Yeah, I mean, so to be clear, there are dozens of people who offer this type of testimony, but of course there are, hundreds of cases involving. Mm-hmm. So it is cool, absolutely, to be called by someone who's interested in retaining an expert on this area of research. But it's interesting because there's lots of different ways I'll be contacted by defense attorneys. Some people will sort of find me organically online. Often I get referred by other experts in the area, so colleagues who know that I do this type of work, who either can't take the case or they don't want to take the case because they're taking a break from consulting or whatever it might be. So I'll get referrals that way sometimes. I'll sometimes get referrals from other defense attorneys that I've worked with. And then I also am on a roster of experts for some jurisdictions. So for instance, I'm listed as an expert in eyewitness memory for the Commonwealth of Massachusetts as well as the state of Michigan.
Okay, so you're like on a registry of like people who know kind of what they're talking about.
Correct.
So you said like the bias towards people within your own race. Are there other kind of eyewitness details that you find you're commonly bringing up during these consultations?
There's lots of different things. It really depends on the case and the factors that were involved in the case. But yeah, I mean, one I think useful distinction to make is experts can comment on a number of different types of variables, but we sort of like to make this distinction between what are called system variables, which are factors that can influence the likelihood that a witness is accurate, that are under the direct control of the legal system or legal system actors. So this are going to be things like, how was the lineup administered? How many fillers were there? Were the fillers plausible alternatives to the suspect? What sort of instructions did the witness receive? Right? Those are all things that I could evaluate. Then on the other side of that, you also have a class of variables we call estimator variables, which are also variables that research has shown have an impact on the likelihood of a witness to be accurate. But these are things not under the control of the legal system. So these are going to be things like, was the crime committed outside at night? Was there limited lighting available? What was the distance between the culprit and the witness? Was there a weapon present, right? These are things that are not under the control of the legal system, but that experts can also evaluate and, report whether they would or would not have an impact in the case on the likelihood that the witness would be able to make an accurate identification.
Do you think that your studies in like psychology and the legal system have influenced your own life or the way that you kind of go about things or your understanding of how your own mind works or how like your day-to-day happens?
That's an interesting question. So I'll be the first to acknowledge that I live in, a very safe area. I'm in a very sort of privileged socioeconomic class. So I have been fortunate to never sort of fall under the suspicion of a legal actor of having committed a crime. So I don't think it's sort of been, I guess, that directly pertinent to experiences that I've had. But
Maybe, yeah.
I guess I'm always aware that it could happen, and I will sort of wonder, like, what would I do in these circumstances? And frankly, anytime I read cases or I conduct research, I always like to try and put myself in this position and think, you know, what if I were innocent in this situation? What would I do? And if I'm not sure, or if I think I would take that plea even if I was innocent, or I would do this, you know, because I would think it was in my best interest. Those are the questions I do think I try to linger on. If I can sort of put myself in that situation and realize the pressure here is just so great that it's either hard for me to see myself being able to, again, sort of hold on to that resistance of being innocent, or I can absolutely see myself just failing to, then I think those are the contexts that I really try and dig into and think about what are ways we can try to reduce and mitigate this pressure so that, again, we're doing a better job of preserving innocent defendants' reticence to plead guilty.
Yeah, so I think, like, an example that I like to think about is in all of the biases that I learn in, like, my psychology classes and maybe some of my philosophy classes about, like, how logic works, I'm very skeptical of the initial conclusion that I draw from anything, really. And so that's something that's kind of a learned behavior I feel like that I've garnered from learning about psychology or learning about philosophy is understanding my own biases. When I see something, it's like, okay, well, that's probably not them personally. It's probably like the fundamental attribution error. It's probably just like they had a bad day or whatever. And I wondered with your specific research and biases, in knowing that your own eyewitness report might not be super accurate, does that influence your confidence in the things that you see and the things that happen to you? Do you find that you're often like questioning yourself as to whether or not you saw was valid? Like, how does that kind of work?
Yeah, I will say I don't trust my own memory particularly strongly, particularly my autobiographical memory. Because of course, as far as, you know, semantic knowledge or knowledge of basic facts or something I've read, I can just look that up and check myself. But as far as memories of things that, yes, I can't just fact check in some way, I'm pretty skeptical of my ability to remember things accurately. As far as judgment and decision making, I don't know if it's my research area that's really informed my general skepticism or just the fact that I try to always be in that sort of researcher science mode where I'm just generally skeptical of things. But I guess, yeah, I probably would just be considered a skeptic about most things, most news stories, anything like that. I generally just sort of greet everything with skepticism. And I guess probably I would like to think it has made me just generally more compassionate for people who find themselves in these situations, right, where someone might sort of say, and there's research on this as well, that even when people find out someone is wrongfully convicted, if they find out they falsely confessed or falsely pleaded guilty, you know, they don't feel as bad for them because then they sort of think like, well, you're sort of responsible, though, for the fact that you were wrongfully convicted. So maybe I feel a little bit bad that you spent all that time in prison, but it's sort of your fault as well. I would never endorse that viewpoint because I know, again, all of the pressure that people can be placed under. And maybe before I did this research, I would have been more in the camp of like, well, that was stupid. Why did you do that? That was really foolish. Sort of the fundamental attribution error that you were saying. Like, there must be something dispositionally wrong with you for you to have done something so foolish that, yes, produced this suboptimal outcome, but that outcome can be tied directly to a foolish thing that you did, so it's your fault. I would like to think that, yes, I've become much less likely to do that and much more, again, sort of skeptical of like, this person falsely confessed, aren't they foolish? And more, again, wanting to know, well, what was the context of it? How long were they interrogated? How tired were they? Were they given bathroom breaks? How old were they? What was their IQ? You know, all of these other questions pertaining to the amount of pressure that person could have faced. So I think it has made me, I think, more sensitive to context and situations and how much those play a role in our behaviors.
Yeah, and see, that's super interesting, and that's what I find is really important. When I talk to these people, when I decided that I wanted to study psychology and philosophy, I really wanted to learn things that I could apply to who I am, what I do, how I think, and those things. So I really that's like always a question I'll be asking people is like, how has this affected like your life, your personality? Like, how have you used these things to kind of influence who you are? So like, do you find that when your peers or your friends are telling you some story about, you know, what they did or somebody said this thing to me, do you find that you're kind of like running through your head like, okay, well, the likelihood of that being true, you know, given that they do this is probably not super high. Like, did they text you this or did they say it in person? Did you know what I mean? Like, do you find that you're kind of analyzing these things pretty often, or do you kind of turn off your work brain and then, you know?
You know, sometimes I think it depends on how closely the story is related to, you know, maybe a case that I've read or work that I'm doing. Otherwise, I do feel like I generally do, I don't want to say a pretty good job because it actually comes really naturally to me. I'm naturally a compartmentalizer. I've sort of always been that way. So it's very easy. And again, maybe this is why I'm empathetic to the power of situation and context. It's very easy, kind of like you said, for me to shut off my work brain and not be that person who, and maybe a little of this was learned of like, hey, if you're that person who's constantly like, but did they say that? Did they mean that? Did they really? Are you even correct? Right? Are you making all these assumptions that are not justified? People don't necessarily want to hang out with that person.
That's true.
So maybe this is a learned behavior in the sense that I've just learned, you know, I need to shut off that part of my brain while I'm interacting with people, or people might not want to continue interacting with me. I don't know. But regardless, I do feel like I'm not engaged in that mode of thinking when I'm just having conversation with friends or family, unless something they say, right, activates that part of my brain. So, of course, if they're talking about, you know, a criminal situation or any sort of legal case, or if they're talking about, you know, a context that really makes me think about something similar to a plea context or interrogation context or an eyewitness situation, then I guess maybe I can't totally shut off that part of my brain. But for the most part, I don't think it really activates in day-to-day conversations outside of work.
Yeah. Well, it feels like in the context of the legal system and stuff like that, it can be kind of sad or depressive, especially when you're looking at these cases where somebody gets wrongfully convicted, or maybe just looking at things of terrible things that people did, even if they are rightfully convicted and stuff like that. How do you kind of balance, you know, emotionally dealing with things that are kind of negative and then obviously like trying to be like a positive person or, you know, be happy? How do you kind of balance the work-life balance in that kind of way?
Yeah, I think this is one of the ways in which the compartmentalization comes in handy, because when I go home, I'm not thinking about all of the semi-depressing research questions I study, and I'm thinking just about being at home with my kiddos or my husband, and it's easy to just focus on being grateful that I have those things. I think also a point of inspiration for me is looking into some of these wrongful conviction cases and finding so many stories of people who spent years of their life wrongfully incarcerated and now spend their time trying to make the system better for other people. And if someone who was directly a victim of the problems of our legal system can ultimately still be trying to affect positive change in the system that victimized them, then I think the least I can do, being someone who just spends time in that world and has never actually suffered direct consequences of its problems, is try to continue that work for them.
Mm-hmm. And I think that's really wonderful. I wanted to kind of end the episode off with a more positive note, but I like to give the end of this episode, kind of give you the floor to talk about, to maybe run through anything that you've talked about, or if there's any readings that you suggest people do, or there's any work that they suggest that they check out of yours. I like to give this opportunity for you to kind of advertise for your field of research or for yourself. But really, the floor is yours to kind of end the episode out how you'd like.
Sure, yeah. So there's a number of great resources, an increasing number of resources, thankfully, on issues with the plea process. So I've already mentioned a few organizations, but again, I'll just note a number of organizations that have produced their own reports on issues that they see with the plea system. So Fair and Just Prosecution released a report, I think it was called an Issues at a Glance brief, talking about their perceived issues with the plea process and making a few recommendations. The American Bar Association had their plea bargaining task force that released its report in 2023. That report has also been endorsed by the entire American Bar Association. The Trial Penalty Coalition, I believe, has some resources on their webpage. And then the Plea Bargaining Institute, which was, again, founded by Lucian Dervin, actually their goal is to make a number of resources available regarding the plea process. So they have a number of legal briefs concerning the case law surrounding plea bargaining and plea practices in the U.S., and then we'll eventually also be posting research briefs as well regarding some of the most important research that's been conducted in this area. And then in addition, as far as my work, so I have a Psychology Today blog called The Injustice System, where I write about issues concerning guilty pleas. I also sometimes highlight particularly egregious cases that have involved either guilty pleas or other psychology and law research issues. And then I have a professional webpage, just MikoWilford.com, as well as a PLEA Lab webpage, and, can be followed on all the standard social media, X, sites, ResearchGate, LinkedIn, all of those, where I'll post updates to the blog and research publication updates. But yeah, a list of my publications can be found on my CV, which is also available on my professional webpage. So,
Well, it was awesome having you on, Dr. Wilford. Thank you.
Thank you for having me.